Welcome everybody. We have a real treat today. We have with us Frederick M. Abbott, the Edward Ball Eminent Scholar at Florida State University, where he teaches international law, international trade, and many other subjects. Professor Abbott is really too well known to summarize his bio. He's the author of numerous books, including our case book that we use in international IP here, and recently the author of UNCTAD's resource book on the flexibilities of the TRIPS agreement, which is really a monumental work with other authors there. He's written numerous books. He was a graduate of the Yale Law School, I must say, and also as an LLM from Berkeley. He's a counselor and advisor to every NGO and every international governmental organization involved in access to medicines, WHO, WTO, UNCTAD, and he is a lead advisor to Doctors Without Borders on all of these issues. I have a long official biography, but I prefer to introduce him on a more personalized basis. Fred is really famous for his work on global public health, in particular access to medicines in the wake of the TRIPS agreement of 1994, the WTO agreement, which made patent protection obligatory around the world and made it very difficult for poor countries, people in poor countries, to get the generic medicines that were previously available. In these issues, he's legal advisor to Médecins Sans Frontières, Doctors Without Borders, and he's been advisor to governments on all aspects of these issues. He was, it's safe to say, let me stop just a moment to welcome Professor Ruth Okediji from the University of Minnesota, who's also here visiting today and very active in these same issues. Fred, it's safe to say, has been the lead negotiator in the Doha round's efforts to modify and address the difficult issues of access to public health that were created by the TRIPS agreement. He was instrumental in obtaining the Doha Declaration on TRIPS and Public Health of 2001. He was instrumental in negotiating the subsequent agreements. Some of you are familiar with them, either because you've studied them or because we had an earlier program, the decision of August 30th and the now amended TRIPS agreement about which he will speak. He was key counsel in the famous South African case on which 42 pharmaceutical companies attacked the South African policies and were ultimately defeated in a major milestone in this route. He's deeply involved in the current Novartis litigation in India. He's also been advising the Latin American governments on the free trade agreements, which is one of the key aspects of his talk today. I must say he has done that only to watch one government after another sign these agreements, which cut back seriously upon the access provisions that we were able to get into these other provisions. As many of you know, we are now once again at a crisis turning point owing to the Thai government's recent imposition of 3 compulsory licenses a few weeks ago that was featured on the BBC the night before last. In this connection, only last week, Fred organized a major conference at Florida State University on setting regional priorities for access to medicine with all the players there. And I think we all learned a lot of things. As much as we know, I think we all learned a lot of new things there. And he has decided in his conversation with you today not only to speak about the free trade agreements, but to share some of the important findings and results of that conference with you. It is safe to say that there is no development affecting public global health and access to medicines today for the poor in which Fred Abbott has not participated. And there is no single person who has done more to advance the cause of the poor generally in the global public health arena. It is truly a privilege and an honor to welcome Fred Abbott here to do today. Thank you.
Well, thank you very much, Jerry, for that exceptionally kind introduction, which will be very difficult to follow. And thanks also to Professor Bradley for the invitation to be here today. I've known Professor Reichman for a very long time. I think that Jerry, if he does nothing else, can now die happy because the Supreme Court has recognized a liability rule for patents, which he championed for 15 years, and one such development in a lifetime is enough. Yeah, I'm very grateful for him for the invitation, and also to see my other old colleagues and friends here at Duke Law School. The title of the presentation I'm scheduled to make today is Free Trade Agreements and the Reshaping of Global Pharmaceutical Supply Implications for Development and Access. But what I want to do, and I've tried to do it fairly briefly, is give you an overall picture of how the global pharmaceutical supply system has been evolving over the past 15 or 20 years, because without that background, one really can't understand what the place of the free trade agreements is in that system. As with everything in life, I suppose, a good part of the devil is in the details. And I'm going to give you some details today, but obviously not all of them. I had sent here, but that will eventually be posted, 3 specific papers in this area: a reflection paper on global pharmaceutical regulation 2007, which last week at my own institution I tried to basically lay out the state of the world in pharmaceutical supply in 20 pages, and you might find that useful. Also an article from the American Journal of International Law, which basically describes the process in which the well-known August 30 decision on compulsory licensing of the WTO was negotiated and adopted, and some very specific details about negotiating positions and the balancing of interests in those negotiations. And the second part of that article then turns to the FTAs and their implications. And finally, a paper done for the International Center for Trade and Sustainable Development, which looks at the provisions of these FTAs in light of U.S. federal law. That is, most of these FTAs are in fact trying to export a brand of U.S. intellectual property and pharmaceutical regulation to foreign countries. As it happens, some of those provisions are even stronger than our U.S. domestic protections, but as you probably are aware, Congress, in adopting these agreements, makes specific provision that they are not self-executing or directly effective in U.S. law. So it's conceptually possible for the United States to enter into commitments exceeding our domestic legal system, but to have those potentially create international legal liability without creating a specific domestic cause of action. Jerry mentioned some of the work I'm currently doing. One of the more interesting current projects, which is actually being funded by the U.S. government, is working on transfer of technology in the pharmaceutical sector, specifically for Colombia in South America, but it's also a project involving Brazil and Mexico, where I'm working with the local industries and the governments and regulatory authorities and the research institutions to try to improve both the R&D structure and the regulatory structure in ways that will allow local pharmaceutical manufacturing to be carried out more efficiently. And all of these agreements that we're going to talk about today really provide the backdrop for that. And one can witness very close hand how governments and industry have to struggle with these provisions. But to turn to the general backdrop, before 1995, countries differed widely in the subject matter scope of protection of their patent laws. So if one did a survey in the 1980s of national patent laws, one would find that most, and certainly many developing countries, excluded pharmaceutical products and nutritional products from product patent protection. And this led, or at least allowed, the development in a number of countries such as India, Brazil, Argentina, to develop very healthy generic drug manufacturing industries, that is, producing off-patent what is on-patent elsewhere. And for example, before 1994, Brazilian industry produced about 55% of the locally used so-called active pharmaceutical ingredients, or APIs, which are the key ingredient in drugs. After 1995, when the TRIPS agreement came into effect, you had transition provisions. So the tough negotiations, there were 7 years of negotiations that ultimately led to the adoption of the TRIPS agreement. At the end of the day, the way developing country interests were protected, because they would be going through an economic adjustment period, was to include for pharmaceutical product patent protection a 10-year transition period. That is, you didn't actually need to provide that protection until January 1, 2005. In fact, most all developing countries and those with good generic manufacturing industries much more rapidly changed their laws. So, for example, Brazil, as of 1996, had in fact implemented pharmaceutical product patent protection in national law. Only India, of the major producing countries and the API producers, actually took advantage of that transition period, and what that allowed India to do was to develop the lowest cost, highest efficiency, and in fact, one might say highest quality generic drug producing industry in the world. India supplies many of the generic drugs used, and in fact patented drugs, but under license, produced in the used in the United States. But I would add quickly, because everything in this area is complicated, the way the regulatory structure works, the US FDA goes to India and inspects Indian production facilities in order to qualify them to export to the United States. And the European Medicines Authority goes to India and inspects the relevant facilities for sending drugs to the United States. In fact, Indian producers, and this also applies in China, supply different quality of drugs depending on to where they're exporting. It's much more expensive for a manufacturing facility to be so-called GMP compliant or CGMP compliant, current GMP compliant, than it is to produce even to a moderate level of regulatory requirement. And this is actually a problem that I'm dealing with quite closely today. For example, India and China export a different quality of API to Latin America than they export to the United States. Most drugs in Latin America are produced by local formulators who put in the excipients and the binders and the capsules and then sell them locally. They're really entirely dependent on the quality of the APIs that they get from other countries. And as a consequence, the drugs that are supplied on the market are not of the same quality as the drugs you buy in the United States. And so one of the things I'm working on is how do we get a higher level of quality in some of these regions, and in particular, for example, how do you get API producers in Latin America and other regions, and particularly API producers who are producing to a high quality standard. The consequence of the TRIPS agreement for Brazil was that they went from producing 55% of their own APIs to producing today 5%. So virtually all of the active components of pharmaceuticals today in Brazil are imported either from India, China, Switzerland, the United States, including Puerto Rico, and so forth, which is an enormous change to the Brazilian structure, and for that and other reasons turns out to be very expensive for the Brazilian public health system, and we'll return to that in a bit. So to continue setting the stage a bit, most developing countries, including, for example, South Africa, implemented the TRIPS agreement. South Africa did so with the famous Medicines and Related Substances Control Amendment Act of 1997. That act, which authorized parallel trade in pharmaceuticals, you probably know this, but parallel importation refers to the importation of a drug legitimately put on the market in a foreign country. If you allow open parallel trade, you don't allow the domestic patent holder to block the import of a drug if that patent holder or an authorized person has placed it on the market in a foreign country, and it's one of the ways you ameliorate pricing problems. One of the things our Congress is doing, and it's had on the table in several sessions, is to potentially authorize parallel trade in pharmaceuticals from OECD countries into the United States. In any event, South Africa was sued by 39 pharmaceutical companies for violating the TRIPS agreement. I take it by now we all know what the TRIPS agreement is. That lawsuit didn't really only have to do with things that were illegal under the TRIPS agreement. In fact, point of fact, it had to do with nothing that was illegal under the TRIPS agreement, but that's the outcome of the litigation. But what the pharmaceutical industry was worried about was not only parallel trade and or compulsory licensing. In fact, what they were more worried about was a so-called generic substitution law that had been adopted locally, and as you know, in the US we have generic substitution laws are ubiquitous, and also a price control system. It happened to have been called a single exit price in the South African legislation. Under tremendous pressure from NGOs, and because they had literally zero legal case despite all the noise, the pharmaceutical companies eventually withdrew and paid the government's legal fees. Shortly thereafter, the United States commenced a legal action against the government of Brazil at the WTO regarding a local working provision in their compulsory licensing statute. Again, you began to have an outcry from NGOs. The U.S. withdrew the case with an understanding with the Brazilian government. But what had happened at that stage was the developing countries were really seeing that their legislation would be challenged under the TRIPS agreement. So they weren't going to be able to develop and pursue their preferred public health policies. And this led, in what is, of course, a long story, to eventual adoption at the WTO of the Doha Declaration on the TRIPS Agreement and Public Health, which confirmed the flexibilities of the TRIPS agreement and provided an interpretative provision that says governments can and should protect the rights of their citizens to public health and provide access to medicines for all. And that secondarily led, in its famous paragraph 6, to another 2 years of negotiations regarding a very minor point in the TRIPS compulsory licensing provision, Article 31F. Article 31F said if you issue a compulsory license, it had to be predominantly for the supply of the domestic market. And, well, let me see, this would be a good time to explain very briefly what the 31F problem is before going on. The 31F problem comes about as this. So now it's January 1, 2005. India now covers pharmaceuticals with patents. Prior to that date, if you were a developing country, if you were in Africa, and you needed an essential medicine, and it was on patent, and you wanted to issue a compulsory license and make it yourself, prior to that, you could say to India, okay, we've issued a compulsory license, you've got the medicine off patent, just send it to us. After January 1, 2005, if you went to India and said, supply us with the medicine, India would say, no, I'm sorry, we can't. That medicine is now under patent, and we cannot issue a license in which we are only exporting to you because we must predominantly supply our domestic market. Now that sounds like a relatively small problem and that people of goodwill and good faith could work that out without too much trouble. But that then led to 2 years of rather painful negotiations at the World Trade Organization until finally was adopted the so-called August 30 decision which has then subsequently been codified as an amendment, but which hasn't yet come into effect. All right, so now we're approaching January 1, 2005. You're wondering when I'm going to get to FTAs, and it's going to be pretty soon. We're approaching January 1, 2005. In the transition mechanism, there's something called a mailbox, another layer of complexity. And the mailbox says during that 10 years, you can submit a patent application even though we're not providing patent protection. And at the end of the transition period, we're going to take all of those patents out of the mailbox and process them. And we're going to treat them for patentability purposes as if we're looking at it back at the date that you filed it. So you won't have lost novelty. Well, what happened in the 10 years? Well, when they opened the mailbox, there were 9,000 pharmaceutical patent applications. Now, bear in mind, during that 10 years, how many new chemical entities were developed in the world? 300. So you have 9,000 patent applications and 300 NCEs, meaning that you have 8,700 patent applications for something else. Now, of course, Professor Rye can explain to you that these something else things are very complicated, and you may have 60 patents on a single drug, and there's all kinds of different salts and esters and formulations and so forth. So it's not a completely inexplicable development, but it ties into what then the free trade agreements are all about and the problems that they raise. So now you've got a twofold problem after January 1, 2005. Every new medicine must be subject to a patent in India, and everything that was in the mailbox for the past 10 years is potentially subject to a patent. Now we are now in the midst of processing some of these applications. Professor Reichman mentioned the Novartis case. I'm not going to discuss that now. We can discuss that in Q&A if we have questions. But the problem we have is that if you just take HIV/AIDS, which is maybe the easiest case, many of the first-line HIV/AIDS drugs were patented even pre-1995. And you may not have a mailbox problem with so-called first-line antiretrovirals, but we are very rapidly and increasingly seeing that the world is transitioning to second- and third-line antiretrovirals, so that while we today have available first-line antiretrovirals for $150 a year, second- and third-line antiretrovirals may run from the low thousands to the even tens of thousands of dollars for a single year of treatment, depending on the level of treatment. So we're quickly running into a situation in which if all of the countries treating all of the millions of people with HIV have to pay for second-line antiretrovirals at patented prices, public health budgets are going to run out very, very quickly. And this problem is growing as we speak. Now, while we were busy negotiating the August 30 decision at the WTO, the pharma companies were busy in their own right, and they were busy with the U.S. trade representative beginning to negotiate these free trade agreements with principally developing countries, but not all. And these free trade agreements contained provisions relating to intellectual property in general, specifically, for example, with respect to patents, and also in a segment nicely named certain regulated products. And I'm not going to try to go through the whole dynamic of the political economy of these now, but what do these FTAs do? Well, they vary, so there's no single model, but let's say the main points the U.S. is trying to get are these. First, they require patenting of new uses of known compounds. And you noted that in the United States, we first developed the idea of the method of use patent for an existing compound. Then we developed a second medical indication patent. And today, our Court of Appeals for the Federal Circuit is allowing patents on doses, routes of administration, patient populations. We're getting to very, very narrow bands of patentability, not on substances, but what you are using them for and how you are formulating them. They are requiring patent term extension. That is, if there's delay in regulatory review or delay at the patent office, you get an extension of your patent term. They are putting in a limited scope provision on patent exceptions to patent rights, which probably, I won't say categorically, but probably means that when the Supreme Court decided Merck v. Integra Life Sciences dealing with research exceptions in pharmaceutical patent law, it probably violated our free trade agreements. For Singapore and Australia, it limited the grounds for granting compulsory licensing. They try to restrict allowing parallel trade. For Australia and now South Korea, they've allowed the United States to intervene in pricing decisions, in their government reimbursement regulatory schemes. But these really, while they're important, aren't the critical parts for developing countries, because the real critical parts are provisions relating to marketing exclusivity and so-called patent regulatory review linkage. And what these provisions say is that when a party, a person of a party, a pharmaceutical company from the United States comes to a developing country and registers a medicine, it automatically gets a 5-year period of marketing exclusivity regardless of the patent status. And in addition, it says that, and whether or not a submission is made to this country in terms of data or the clinical dossier, that doesn't matter. If a clinical dossier was submitted in the United States, that constitutes effective submission of the dossier in the developing country. And if the developing country approves the drug on the grounds that it was approved in the United States, that also constitutes adequate submission for the purposes of these agreements. In addition, it takes the definition of what is a new product for granting this marketing exclusivity and expands the definition beyond the TRIPS agreement to refer not to new products in the term of new chemical entities, but only in reference to drugs that have not been previously registered, which could really be anything. The implications are pretty serious if you're a generic producer in a developing country about the impact these marketing exclusivity rules may have. I can go back into that a little bit more later, but in question and answer. But also, it doesn't provide any exceptions. It doesn't say if you grant a compulsory license or if you use the August 30 decision that you overcome the marketing exclusivity. This is something the European Union specifically put into its implementing legislation for the August 30 decision, but which USTR has not acknowledged for the United States. A very serious problem is the linkage problem. In the United States, we have a very complex linkage system. It's a very complex system. It's a very expensive system. It follows something called the Hatch-Waxman Act. But basically in the United States, in the 32nd version, when a pharmaceutical producer has gotten a patent, it lists it in something called the FDA Orange Book. The FDA, so if you go to the FDA website, you can find the Orange Book, and in the back it's got all the pharmaceutical patents, all the expiration dates, and so forth. When a generic producer comes to the FDA and wants to file something called an abbreviated new drug application, and if there is a patent listed in the Orange Book, the applicant is required to notify the patent holder, and it may, under something called the so-called paragraph 4 certification, also say that there is a patent, but we don't think it's valid. And so FDA, go ahead and approve the drug because the patent's invalid. Then the patent holder has 45 days to file a cause of action in district court seeking to block the medicine or the approval of the medicine. This is a system in which companies spend literally millions of dollars on litigation going back and forth across patents, hugely complicated and difficult to administer, and which our Federal Trade Commission found 3 years ago was rife with abuse, but we've tried to fix that. Well, what we're doing with developing countries now is we're saying you have to have a linkage system. The provision says you may not register a medicine if there is a patent without the consent of the patent holder, period. You need the consent of the patent holder to register a medicine for approval. Now, bear in mind, I told you before, if you go to Colombia today, there are 3,500 pending pharmaceutical patent applications in Colombia. There are pending in Brazil 7,000 pharmaceutical patent applications, and by the end of next year, the director of the patent office expects there to have been granted 22,000 pharmaceutical patent applications in Brazil. Now, imagine you're the drug regulatory authority and you say, well, I'm looking at this FTA and what it's telling me is I can't register a medicine if there's a patent. Oh, and by the way, there's 10,000 of them listed here and 70 of them relate to this medicine. I guess I better not register it because it would seem that I'm violating this agreement. Now, one can't neglect the fact that, of course, these countries can put in systems like that in the United States. You can develop a very complex Hatch-Waxman type model or some other type of model that would theoretically allow private applicants to challenge the patents before the drug regulatory board so that medicines could actually be registered. But for those of you who deal with developing country legal systems and bureaucratic structures and the structure of the legal community, this is something that is really beyond the capacity of most developing countries. And so what is the regulatory? Well, I could go on about that. That's what I do. I try to help design these systems and train lawyers and government officials to make them work. And I'm telling you, this is an enormous problem for regulatory authorities in developing countries. Now, of course, one can argue, well, yes, but doesn't a patent holder eventually have a right to sue to get a drug off the market? So what you're really talking about is the difference between blocking the medicine from ever being registered and entering the market and allowing the medicine to go on the market and then having the patent holder bring a private suit. And that is true, but what you're doing is effectively making the process of challenging the patent essentially something that's never likely to happen at all, and placing the government and the health regulatory in the position of being the patent enforcer as opposed to the private patent holder to establish the validity of its patent in litigation. The net effect of the, and if you think these provisions aren't important, you can see how important they are by looking at the work the pharma industry does in Washington with USTR in reviewing the legislation and commenting on it, where they are concerned with every comma and dot in this legislation. And if it weren't important to them, it's hard to think that they would really be spending that much money, time, and effort trying to get the legislation adopted. The net effect of this is you are having a dramatic impact on the ability of generic producers to function in the local markets in developing countries. You're blocking Indian and Chinese and Israeli generic producers from being on the market, and you're turning the market over to either patent monopolies or authorized generic monopolies, raising the price of medicines. The United States has put Chile on its special 301 watch list only for adopting 2 levels of protection in its marketing exclusivity law. That is, Chile said, you have to come and register the market within a year after you register it in the United States. And if you don't put it on our market within a year after that, then you don't enjoy your marketing exclusivity. And we're threatening to withdraw Chile's trade rights in the United States on the basis of having adopted 2 protective provisions, one of which is pretty much straight out of European community law. Now, and we had a very interesting talk last week from one of the heads of the Dominican Republic pharmaceutical industry just about the nightmare that they're going through attempting to comply with this law. Of course, there's another side of this story. Why are we doing it? I mean, isn't something in this for the United States? Well, we're protecting a mercantile position in our pharmaceutical sector. We argue that by collecting more money from developing countries, we can do more R&D. In fact, we only spend 15% of pharmaceutical company R&D goes into research and development. 35 to 40% goes into production, and 50% roughly goes into the wonderful commercials you see on TV, and advertising and promotion and lobbying and executive salaries and so forth. So what we're saying is we need to collect a lot of rent from you in the South so that we can finance this system, of which 15% is going to the R&D which we're providing for you. And also, of course, one of our arguments is, well, yes, but the Chinese and the Indians are getting better at this. We're in a mercantile battle, and we need to defend ourselves from them. That's another part of the equation. I thought I was going to talk for a relatively brief period of time and do a lot of this in question and answer, but I tried to convey a fairly detailed picture of this whole arrangement, because it's hard to understand how one part of the puzzle works without looking at another part of the puzzle, and it's a pretty complicated puzzle. So with that, I thank you.
I have a couple of questions that I will ask. Maybe to get things going. Let me see who's ready for a question. A moment. Professor.
So one thing that I find very interesting about you're talking about this whole area is in the international realm, is that in the domestic context, to the extent that we're seeing scaling back in the patent law domestically, which is very small to that extent, but to the extent we're seeing it, for example, through cases like the eBay case, which got Jerry his liability rule, it's because the information technology industries are very upset with very expansive patent protection. And I suppose that because of the way that patent protection is being implemented in these FTAs, there's no information technology component really to what's being done, or it won't affect the information technology industries at all, so therefore they don't care. Is that an accurate representation? Because basically what the political economy of the domestic sphere is that pharma is in a pitched battle with the information technology industries. And so Congress doesn't know who to cater to, or who, they're not quite captured because they've got opposing very powerful interests. But there's no similar industry interest in the international sphere.
Well, there are some fairly detailed provisions in copyright and information technology in the FTAs. They are mainly trying to bring in the WIPO Copyright Treaty and the WIPO Performances and Phonograms Treaty, but they do increase protection for most of the countries in which are participating, but not as compared with US standards. And then they tack on basically the identical protection for the internet service provider sector as part of the chapter. I think much of it probably has to do with the fact that I guess local IT providers abroad are either in the European Union, in which they largely share, to the extent that there is a protectionist agenda in the United States in IT, share that agenda and aren't too concerned about what's happening, and that maybe you don't, because IT doesn't have the same constituency in developing countries as medicines, you're not getting the same level of pushback. Having said all that, the provisions in copyright are not nearly as, for lack of a better way of saying it, TRIPS plus, or certainly WCT plus. In fact, they're WCT basically consistent. I don't mean to answer too lengthily, but we've looked at this pretty closely. Others have. That's not my specialty in particular. It's an enforcement where you get a ratcheted up standard. Monetary penalties, criminal liability, and so forth are increased in these agreements. Why the U.S. IT industry might not be as concerned about these FTAs as foreigners are about the FTAs. I haven't really looked at that from a political economy standpoint. My guess is really that it is the movies and some elements of the software, the same ones who are pushing the high protection agenda, that are interested in this, and the softer IT side just really isn't paying that much attention.
They're probably paying attention to the SPLT negotiations where standards could be set.
Right, and they're opposing high protection, that kind of thing.
But I have a couple of
But not
questions.
EMT.
Yes, that I'd like you to comment on for the benefit of our audience. One, you mentioned the APIs, the active ingredients that are the key to these pharmaceuticals. And it came out at your conference that what Engelberg had said in this memo, that we're not making our own active ingredients anymore, but more and more are being farmed out to India and China for our own drugs. And then they'll be under patents, and then the people who have the patents are telling them don't sell them for purposes of generic drugs, even if there's some legal applicability. So there could be a serious problem in getting APIs, even if all your legal ducks are in a row. Would you like to comment on that?
Well, I mean, that's true. I wouldn't, in the first place, though, the United States and Europe do produce a significant part of global API production. So there's a lot there. But it is also true that an increasing amount of that production is being outsourced into China and India. And to the extent that those production sources are controlled by US and EU patent holders, the APIs are not going to be available, which is just part of the basic problem. The fact is that you don't have to obtain patent protection everywhere if you're a pharmaceutical company. If you can obtain it where the APIs are produced, and you can't easily transfer API production capacity, you've already stopped production and sourcing. The fact of API concentration is a big problem for many countries because they are limited in their sources of supply. Those sources of supply have been increasingly concentrated. And it's why a country like Brazil, I mean, I'm not sure I've answered your question well enough, but the Brazilians are sitting in their government offices saying, we need to figure out a way of dealing with this problem. We need to get back into the API market, and that's where the IP and marketing exclusivity problems then become more than merely ephemeral. Those become very serious problems. You can't produce the APIs locally. And the problem is, when you understand the industry, formulators are dependent on API suppliers even to make small changes to their formulations. And if you're importing an API from India and it's coming on a ship that takes 3 weeks to get to your port, and it gets there and it's the wrong thing, you really don't have much of a choice. It's very hard to say, oh, I'm just going to reject that and send it back and then spend another 6 weeks waiting for your raw materials to come. It's very difficult to tweak your product. So the lack of localized API supply is a big problem in more than one way.
Thank you. Now, one more. Let's talk a little bit about potential for good outcomes. We've seen a lot of potential for bad outcomes. And one of the good outcomes has been created by the December 30th agreement in opening the possibility of local production in so-called least developed countries, the poorest of the poor, Bangladesh, lots of African countries, and Haiti over here, where these countries are free quick in 2016. And some efforts are being made, particularly by the German government, to recreate in at least some of the African countries the Indian generic pharmaceutical capacity. What are a few words about that opportunity?
Well, you're quite right, and of course, well, you're working on that as well. But in the Doha Declaration, it was a very important aspect. Paragraph 7 of the Doha Declaration says, least developed countries need not adopt pharmaceutical product patent protection until 2016 or data protection. And perhaps more importantly, if they have data and patent protection, do not need to enforce it. Because many least developed countries are former colonies of colonial powers, and in fact have had pharmaceutical product patent protection in place for a long time, and even have quite a number of pharmaceutical patents granted. So it provided a wide opening, and it essentially says to these countries, you can really do whatever you want in terms of manufacturing a production facility, and even in exporting from that production facility. So there's quite a bit of opportunity. The problem with exporting is you can only export to a market in which there is no patent protection or in which it can be easily waived as a least developed country, or if you're a developing country or another country, then you have to grant a compulsory license to allow the medicine to be imported. So if in my discussions with pharma people in the past 8 years, the happiest people are in Bangladesh. They are rapidly ramping up their manufacturing capacity in Bangladesh. There are some high-quality producers in Bangladesh. As Yolanda Taylor from the World Bank explained to us last week, though, Bangladesh, like even India and other countries, but let's take Bangladesh, has a very weak domestic regulatory authority and very little government interest in improving its regulatory capacity. Essentially then, for the Bangladesh suppliers to be competitive on the world market, in what they are doing is they're self-regulating, right? The good producers are hiring experts in the pharmaceutical sector to come in and essentially monitor their production, but that there is an element of Bangladesh production which is not good. So these are serious problems, number one, but as you've pointed out, there is legal possibility to make alternative systems work. There is legal possibility to make alternative systems work under the August 30 decision, under Article 31 of the TRIPS agreement. You are working on making that happen. The real key is making governments want it to happen, because no matter how good of a lawyer you are, if the government of X developing country doesn't take on the interest, it's not going to happen.
Question. Madam,
Okay. Thank you, Fred. I actually had two questions, and I'll start with the one raised by your last point. I wonder if there's a way that we can create incentives for these developing countries and the least developed countries to invest in taking advantage of alternative designs. I mean, we clearly create incentives for them to deal with corruption. We create incentives for them to improve an environment for foreign direct investment. We've created trade sanctions to create an incentive to invest in IP laws. I'm just wondering if in working through some of these issues, with the demand for alternative designs to address this problem of supply has not been sort of obscured or put to the side. I'm just wanted you to address that for one quick minute. My second question really has to do with the 15% that's going to R&D. I mean, one troubling issue with global health, public health, is the diseases that truly affect the quality of life in many developing countries. Take malaria, where resistance to existing quinine drugs is really just fallen. People are dying from malaria on a daily basis, in particular women and children. And I just wonder with 15% of R&D going back to the pharmaceutical companies, and with no market in the West for these drugs, and no capacity to purchase them at patentable prices, prices that would be driven by patent protection, what are we doing? The Global Fund is not working. What can be done, or what is being done in thinking about incentives for the pharmaceutical industry to redirect R&D, or to redirect resources into R&D from the money that's coming from the top?
Okay, those are two very good points, questions. In terms of, how can you give a government an incentive to do what we collectively think is in their own best interest? I agree with you that probably not enough thought has been given to that. I suppose one could envision the World Bank setting some kind of benchmarks, quality of life benchmarks, or kind of addressing pharmaceutical capacity benchmarks, which could then lead to some mechanism for dispersal of funds and so forth. I'm not sure how easy that is to deal with. It is a subject of perpetual amazement, I think, to people who think differently, that some of our literally biggest problems aren't that we can't figure out how to address things, but that we can't figure out how to get governments to want to address them. I mean, that was a key issue in South Africa. It wasn't only that there was an AIDS pandemic. It wasn't only that the pharma companies were making it difficult to address. It was that President Mbeki's government didn't have any particular interest in addressing it. And it was no amount of strong talking tos from the UN representatives were changing the government's views. And I don't, privately incentivizing is a good idea, but then at the same, which is, I don't disagree with that, but then you've got the same problem of how do you privately incentivize without that leading to corruption and mismanagement, which comes back upon itself. So those are really core issues. As I say, we had with us Yolanda Taylor, who's managing really all of Asia in terms of World Bank disbursements for medicines acquisitions, and her biggest problem is getting governments to care. Even if she's making funds available, it is how do I get them to actually want to pay the time and attention to doing this? So it is a big problem. Neglected diseases, I should mention that this meeting we held last week, I mean, all of us involved in this effort realize, and I didn't discuss it today at any detail, is that you can't have a system that is only demanding lower priced drugs. I mean, because eventually that string runs out. And a lot of attention is being paid to, okay, how do we fill the pipeline with new drugs, and how do we do it in a way that isn't relying on monopoly pricing to recover investment certainly as its sole mechanism. And I'll turn to neglected diseases in just a second, but for students who might be interested in some of the key things that are being talked about, I mean, there's many alternatives that people are working on. You have, first, generally, the patents aren't the only way of stimulating innovation. You also have subsidies, naturally. Many governments have subsidy programs in pharmaceuticals. US NIH is a $30 billion a year subsidy, most of which goes to basic research and pharmaceutical development. They have a capacity to change the direction of funding. They don't need to be market demand driven. They can be public health demand driven. Brazil, India, China's ramping up. Others are subsidizing drug development. But that doesn't necessarily affect. India, presumably, is addressing local, including neglected diseases. China worked on anti-malarials, but so subsidies. As you know, I'm sure Jamie Love and now Joseph Stiglitz are both advocating the use of prizes so that you say, I'll set up a $100 million prize for someone to develop an effective anti-malarial, and then once the drug is developed, you're not going to have a patent. We're going to distribute it at a low cost so you can have prizes. Jenny Landau long ago proposed the idea of forcing patent applicants to choose between marketing in the OECD or marketing in developing countries, but not both. That idea may have been a bit impractical as a way to design a patent system, but you're increasingly having people like Drugs for Neglected Diseases Initiative and FINE negotiate licenses with big pharma companies that say, we're going to do some research with your molecule. If at the end of the day we get a nice new drug, you can have it for the OECD, we have it for the developing world, and so you are seeing segmentation of market outcomes. And that just ties into the fact that the other idea you have is public-private partnerships of various kinds, ranging from Drugs for Neglected Diseases, which was designed specifically to address the problem that you're talking about. So now you've got a collaboration of 12 foundations, a lot of them government laboratories in different countries, all pooling their resources to work on neglected diseases, have funding from various sources, including the European Commission, and so forth. So that attempts to get around the demand pull problem. In the US, we have theoretical march-in rights under the Bayh-Dole Act. As Professor Reichman will tell you, the NIH has adopted a pretty narrow interpretation of when you can march in. We've got various people proposing patent pools of different ways where you contribute or buy out key patents and put them into a pool for licensing. We've got R&D treaties. We've got improvements to patent quality. We've got extending the public domain. We've got dependent compulsory license, compulsory licensing for dependent patents. We've got transfer of technology programs. I mean, a lot of attention is being paid to the R&D side of the equation. You know, the fact of the matter is we presently rely on the patent system, which is a market-based mechanism, which has its good points. People stay up late into the night. Biotech companies get funded. You get a lot of neat research on things which people hope will eventually make money, and it really drives one part of the system. But it introduces a major distortion then because it's totally based on market demand. And so if you set up a market, you say, you can either develop a new ED drug, you can develop the fourth ED drug, or you can have an anti-malarial. The market will take the fourth ED drug every time. And that is the marketing exclusivity. I mean, that is the patent problem and direction problem in a nutshell.
Yeah, a lot of people have criticized the August 30th decision as a gift wrapped in red tape, that it's just going to be too administratively and bureaucratically difficult to deploy for effective use, given especially that compulsory licensing is already so rarely used. Why would it be any more for importing beyond domestic supply? Is that a true characterization, and how would you answer that?
Well, I think that concern, with a touch of reality, is largely overstated. I would tell you that if Professor Reichman was representing Kenya and I was representing India, and we needed to make it work between our two countries and we had 3 hours, we could develop a system of documents and get that done for you in half a day. And I don't think that the bureaucratic legal paperwork thing is what makes it difficult. What makes compulsory licensing difficult is precisely what's happened in Thailand, is that Thailand says, we're going to issue a compulsory license. We've actually been trying to get you guys to lower your prices for 2 years. Here's the license. And then the next day, the U.S. Chamber of Commerce, the U.S. Trade Representative, the industry, the Financial Times, the Wall Street Journal, all begin to say, you really shouldn't be doing this. We may have said you could do this, but we didn't really mean that. Now that you're doing it, we'd really just like you to stop. and pick your reason. And so in that sense, making the August 30 decision may be difficult precisely for the same reason the Thai decision is difficult, is government pressure. I really don't think it's because I have to send a piece of paper to the WTO that says I've just issued a license. Now, you also have problems of, well, you have to state the quantity, but it doesn't say you have to state the precise quantity.
I'm actually also referring to relabeling provisions, border enforcement provisions, trade diversion, gray market. You know, if they're not set up to do that kind of thing, is that really going to be effective in assuaging?
But they're coming from the OECD country. That's not a big deal. Helen Tahone was asked this question. She represents
MSN.
Medicine Talking Without Borders. She was asked this question. The same criticism was voiced there, and she said, "Wait, but that's not fair. We haven't needed the stuff yet. Okay, it's just these new laws just went into effect. We were able to get the drugs wherever we wanted them, and you can't say that the system doesn't work because we haven't needed to use it. Now, she doesn't see any legal problems in using it. The question is, she sees exactly what Fred is saying. The question is not in the law. The question is, will the governments issue the license and take action to do it? I can tell you that there are all sorts of people. I can tell you that the Indian law is ready on the books. They can do it. And at Fred's conference, the head of the Indian Pharmaceutical Association went on record saying we are ready to fulfill the term needs at any moment. So it's not going to be
Generic pharmaceutical.
Sorry.
The generic pharmaceutical.
Generic. Yeah.
I don't want to convey to you that it's anybody's ideal solution, right? It does have some requirements. I don't think that any of them are onerous. I don't think, because if it's unreasonable, you don't have to do it. If you have to produce a red pill instead of a blue pill, that's something that formulators can do pretty easily. And if it's too expensive, they don't have to do it. I mean, we went through each and every one of these provisions. We were very careful about it. Of course, I was working and listening to all of the NGOs when we were doing this, and I was also working with all of the developing country governments when we were doing with this. At the end of the day, I'll just tell you that my own judgment was that this system can be used if governments want to use it. And to add the point, this wasn't a negotiation between Médecins Sans Frontières and Oxfam. If someone had said to me, go negotiate the best conceivable deal that you can do, well, we wrote that deal. I could show you 10 drafts of the best conceivable deal. But this wasn't MSF negotiating with Oxfam. It was developing countries negotiating with the United States and the European community, but particularly the US pharma industry, that really didn't want an effective solution. So I think developing countries did the best job they could do under all the parameters, and I think that it will work. Could we have done it in a way that would be better? There's no question about that. But I think until someone actually tries to use it, and countries have already invoked it in ways that have gotten lower prices, I think the critiques, I don't think we could negotiate that deal today in light of the FTAs. I think that is, at least for the time being, the high watermark of where we're going with that.
We're going to have one last question and then we'll have to end. If not, we'll end there, and thank Fred very much for the
Thank you all. Thank you all.